Good day and welcome to a special webinar brought to you by the American Bankruptcy Institute. I am Bill Rochelle, ABI's editor-at-large. Today, we will be analyzing the Jevic decision handed down on March 22nd by the U.S. Supreme Court. Briefly stated, Jevic barred the use of so-called structured dismissals, an innocent-sounding term that was used to allow failed companies in Chapter 11 to distribute their meager assets in disregard of the priorities in Section 507 of the Bankruptcy Code. To discuss Jevic today, we have experts on both sides of the issue, plus neutral observers. On one side, we have David Cuny, Senior Counsel with Whiteford Taylor Preston in Washington, D.C. Mr. Cuny is a member of the American College of Bankruptcy, and significantly for our purposes today, he was one of the folks on the American Bankruptcy Institute Commission to propose reform for the Bankruptcy Code. And I say that because the ABI Commission study was cited in the Jevic decision by Justice Breyer, among other things, to define exactly what structured dismissal is, and also for its statement that structured dismissals are being increasingly common. Next, we have, and I forgot to say that Professor Cuny, or I should say Mr. Cuny, submitted an amicus brief in the Jevic case dealing with Section 507 priorities. Next, we have Jonathan Lipson. He holds the Harold E. Cohn Chair at the Temple University Beasley School of Law. Professor Lipson was an author of an amicus brief for a number of professors on the side of those who won and required in the Supreme Court that everyone follow the priorities in Section 507. Professor Lipson has been with mighty big law firms before he began teaching. He is with Kirkland & Ellis and Milbank Tweed. Finally, or shall we say neutral, is Professor Andrew B. Dawson from the University of Miami School of Law. Professor Dawson this spring is ABI's Scholar in Residency. Thank you for being with us, Professor. And by the way, Professor Dawson knows his way around the Third Circuit. That's the circuit that was reversed in the Jevic decision, because he was a clerk for Jane Roth on the Third Circuit, and significantly also a clerk for Honorable Peter Walsh, bankruptcy judge in Delaware. So now, folks, let's begin and talk about this case. I think first, Professor Dawson, could you give us the basic facts in the case and the procedural history that brought us to the U.S. Supreme Court?
Absolutely, and thanks, Bill. Thanks for having me. So our debtor here is Jevic. They're a trucking company. And significantly for this case, in 2006, they were acquired in a leveraged buyout. Within 2 years of that LBO, they ended up having to shut down. They laid off all the truck drivers and filed bankruptcy under Chapter 11 in Delaware. Those laid-off truck drivers successfully brought an action under the WARN Act, sought claims under the WARN Act, and ultimately obtained a judgment, $8.3 million of which was entitled to a wage priority claim. Meanwhile, the Unsecured Creditors Committee, on behalf of the estate, sued attacking the LBO as a fraudulent transfer. Ultimately, that case was settled, and that's really the issue here. It was settled as part of a structured dismissal, whereby the defendants would contribute money to pay, so CIT would contribute money to pay the administrative and legal expenses of the committee, and Sun Capital contributed $1.7 million on the condition that the money not go to the WARN Act plaintiffs. As part of that settlement, the Chapter 11 debtor, Jevic, would agree to dismiss the case. And that's our structured dismissal. The bankruptcy court approved this order, I think somewhat begrudgingly, accepting the argument that absent the settlement, there simply would be no distribution at all to the unsecured creditors. The district court affirmed, and the Third Circuit affirmed, sort of the same idea. This was a little bit for the unsecured creditors was better than nothing, and this is a rare case that justified deviation from the bankruptcy code's priority structure.
By the way, Professor, why is it that the owner of the business wanted to cut out the WARN Act claimants from this distribution?
At the time, it was just they didn't want to feed the WARN Act litigation. If the money from the settlement went to the WARN Act plaintiffs, they would just be giving money to plaintiffs in order to fund the litigation against the employer and Sun Capital.
Righto, not unimportant, I suppose, which, by the way, was a litigation that they ultimately lost in the Third Circuit, if memory serves correct. So we went up on appeal, Professor. What happens there?
On appeal, the Third Circuit approved, saying, look, this is kind of problematic. We're skipping over the wage claim priority, yet it is in rare cases that may be justified. And this looks like one of those rare cases. Accepting the facts as the bankruptcy judge had found them at the bench ruling, saying, look, I don't like this, but absent approval of this settlement, there will be nothing available for the unsecured creditors at all.
All righty. So we have the Third Circuit. By the way, in the Third Circuit, was the opinion unanimous or what?
No, we had a dissent. A dissenting opinion expressing concern that, in part, expressing concern with the premise of the hypothetical. How do we really know that there would be nothing left over but for this settlement? All we have is really the testimony of the people who structured the settlement to begin with.
Yes, that's right. The dissenter agreed with the notion that you could have a priority skipping distribution in dismissal, but said this was not a proper case. Now then, how come it is that the Supreme Court granted certiorari?
Well, the Supreme Court granted cert to answer the question of whether a settlement could be approved that deviated from the bankruptcy code's priority structure. If we could have a priority skipping settlement.
And did we have a split of circuits here, or what was the rationale for going to the Supreme Court?
On that ground, we have a split of circuit, but when we got to the Supreme Court, as we'll talk about, I suppose, a little more depth later, the issue before the Supreme Court was actually presented much more narrowly. Can you have a structured dismissal of this type, not just a settlement, but a structured dismissal that would deviate from the priority structure? And on that point, there really wasn't a circuit split.
Very, very interesting. That keys into the dissenters who believed that certiorari was improvidently granted, but we'll get to that later on. Mr. Cuny, can you tell us, generally speaking, what it is that you briefed in the Supreme Court and what it is that the proponents of the structured dismissal argued to the justices?
Right, and thank you for having me, and yes, I can. So we, our firm filed a brief on behalf of another group of law professors, and we initially got involved because of the way the cert petition was framed. And it was framed, we think, differently than as the case wound up. And I know when I read the cert petition, there was a sentence that jumped off the page to me that said the single most important principle of Chapter 11 is the rule of absolute priority. And then they went on to say strict adherence to absolute priority is critical to effectuate the choices and policies that Congress has made. We were concerned at our firm that there was a profoundly an overstatement of 1129B, and that initially the case was being cast more as an 1129B absolute priority rule, and then trying to tether that to settlements. And so I think the initial perspective on this case among many was really, this case asked a simpler question: does 1129B apply to settlements? It turned out I don't think that was the question later. So because in my practice and the stuff we do at our law firm, if 1129B was misconstrued or misapplied to settlements, we thought that would do serious damage to bankruptcy practice generically. So we drafted a brief that attempted to trace the history of absolute priority to better define it, and to basically inform the court that if you looked at the arc of the history of 1129B, there was really a movement toward a more flexible, not a less flexible point of view. By the time we got into the case, mostly I think thanks to the Solicitor General, the Solicitor General had kind of said to everybody, I think the petitioners conflated 507 with 1129B, and then the case kind of got corrected to being not an 1129B absolute priority case, but what I'm calling a, quote, priority scheme case, which was just another way of saying 507 instead of 1129B. So in the petition, when the respondent got to oral argument, I think Chris Landau said several things to the court at oral argument. First, he said, I think 2 or 3 times, that clearly 1129B does not apply to settlements. And I don't think the court necessarily disagreed, but I'm not sure they saw that as the issue anymore. And then in his view, instead of being a distribution or a scheme for distribution under 507, in his mind, 363B was really the governing section. And he thought that the ability of a debtor to sell, lease, or dispose of assets under 363B, which is a highly discretionary regime, that controlled, and that there were limits on that discretion, and that the court exercised that discretion here, but that was really the controlling section, and he was really asking the court to reconsider this case more under 363B. He also argued, and I think this was really one of the turning points, he said, in his mind, this case really had nothing to do with dismissals, that what he saw the petitioners asking was that you have the statutory scheme that governs from day one of the case to the end of the case. And I think that spooked petitioners a little bit because they were the beneficiary of some first day motions where they got a huge distribution that really skipped over the administrative claimants in the case. So in any event, we briefed 1129B, Chris argued 363B, and the court essentially went along on 507. So there were 3 ways of thinking about this case.
Very, very amusing. Yes, it was rather exciting sitting there in the Supreme Court watching the oral argument. Do I recall correctly that the petitioner explained that there was a change of counsel along the way that resulted in stating the issues differently, or do I misremember?
I don't remember that. Sorry.
I think that's because there was quite a difference between the petition for certiorari and then the brief later on the merits.
Right.
Well, in any event, Professor Lipson, it is your turn now. Could you tell us, please, what it was that the witness argued in the Supreme Court?
Sure. Thank you, Bill, for asking me to talk about this. As you mentioned, I was co-counsel along with Melissa Jacoby on behalf of 17 law professors who supported the petition, essentially for 2 reasons. The first has to do with the priority structure of the bankruptcy code, and at least as we saw it, the question was simply whether or not the bankruptcy code's priority rules, in particular 507, applied in the making of final distributions in a Chapter 11 case that was being dismissed. And our view was that the answer is yes. It's clear. I mean, to us, it was simply a statutory construction case. So, in fact, it didn't have anything to do with the earlier distributions in the case. And, of course, Justice Breyer is quite clear that this doesn't have anything to do with first day motions or first day orders or what have you. We also think that, you know, there's a common law view of priority in settlement. So we weren't so motivated by the 1129B argument, and I'm not even sure the petitioners were. I think our view certainly was that if you look at cases like TNT Ferry, that, you know, and even Iridium, right, you know, all the courts that approve settlements say that respecting priority is the most important thing. And, you know, the Supreme Court has come out and I think taken a slightly stronger position. The second thing that concerned us, and in some ways this was a bigger concern, at least for me, was that if you read the split opinion below, it really wasn't clear at all what made this case rare, right? So Judge Hardiman says, well, we're not happy about this, but we'll approve it because it's a rare case. Well, when you look at what actually happened, our view was it wasn't rare at all. It's a garden variety failed leveraged buyout. Those happen all the time. And the estate was administratively insolvent. That happens a lot too. So our basic question was, what's the test? You know, nobody has yet explained to me what the test was supposed to have been coming out of the Third Circuit. And for us, the real concern then became that, you know, folks would be, I think, inclined to litigate to test the boundaries. And that is a systemic problem that I think was of great concern to us in particular.
Well, you know, in terms of systemic issues and whether or not the case is rare, the case is really very similar to most others in Chapter 11, where almost inevitably you have the official unsecured creditors committee suing or attempting to sue the secured lender, typically, as was the case here, on a claim that is clearly estate property. So you have a committee suing on a claim that belongs to the estate, but then when you settle, you say, oh no, we're going to not give the money to the estate, but to just a specified group of junior unsecured creditors. That to me makes it not a terribly rare case in that sense, but a case that is rather common in occurrence. Well, listen, tell you what, I think we're now ready to talk about what it was that Justice Breyer told us. And for that, Professor Dawson, can you please give us a rundown on Justice Breyer's decision?
Okay, sure. So Justice Breyer starts out with what could arguably lead to a really broad sort of decision, and then keeps it, at the end, keeps it very narrow. So he starts with the broad principle that the priority structure is just sacred in bankruptcy. It's fundamental. And so we should look at deviations from the code very, very skeptically. But after making that sort of broad statement, he ends up narrowing this down and saying, well, really what we're going to be concerned with here are final distribution. We're concerned about distributions at the end of a case that deviate from the priority structure. So we're not really concerned broadly about structured dismissals, although he'd spend some time, you know, questioning what is the authority for this, for structured dismissals. So we're not really concerned about structured dismissals, and we're not concerned about interim distributions. So the sort of things that David and Jonathan have talked about so far, critical vendor orders, first day motions. We're concerned about final distributions, and when you have final distributions that don't follow absolute priority, that's not allowed. And finally, the court, you know, Justice Breyer says, you know, we're sympathetic to the rare case, but we, not exactly what Jonathan said, it doesn't actually say that we're not sure this is rare, but more of a skepticism that if we were to create a rare case exception, that rare cases could be manufactured, or emergencies like this could probably be, you could argue an emergency situation in almost any case. So we end up with sort of, we start with a broad principle that that priority is sacred, and we end up with a fairly narrower holding, or attempted to be narrower, saying that final distributions that deviate from the priority structure are impermissible.
Now, did did Justice Breyer carve out some kinds of bankruptcy practices that he was evidently not trying to upset with this opinion?
Yeah, he specifically tries to carves out sort of these, interim distributions that might happen along the way that would violate priority rules, so like critical vendor orders, first day motions. He says, these are different. They're different because they don't happen at the end of the case, but they're also different, he says, because they might serve some bankruptcy purpose. They're permitting deviations might be permitted when it facilitates the debtor's reorganization.
And by the way, interestingly, it was the Solicitor General, was it not, that urged the Supreme Court to narrow its opinion and not end up eradicating first day orders?
Bill, I'd like to pick up on that for a moment. I thought the elephant in the room was the first day motions. And I thought the Solicitor General was being, cute's the wrong word. The Solicitor General, I thought, really said two things in my mind that were very clear. One, we think the same rule pertains and that they ought to be prohibited. That is, the same sacred principle, if it applies at the end, applies at the beginning. But then repeatedly said, but you don't have to reach that. And I remember sitting there thinking, well, if it's sacred, why don't you have to reach it? So I think with the interesting thing that Justice Breyer did, he tried on the one hand to elevate or maintain the, I'm using the word sacred again, I think it's a good word, priority, and then say there's no exception here at the end of the case, but certainly at the beginning of the case there could be, because there's some overarching other Chapter 11 type principles. But if you're being a statutory purist, which is where he began, I mean, his decision sort of begins with priority is important. There's no statutory evidence of an intention to deviate, so we have to stick to it. But his suggestion that he wasn't going to touch the early on deviations, I think, lacks the same statutory rationale. It may make more sense. So I think on the one hand, I kind of appreciate what he did in trying to not disrupt the bankruptcy system. But in terms of the underlying logic and rationale, if you're being a pure statutory justice, there's a problem with skipping priorities wherever they occur, except as he said in the beginning of the case, you really can't figure out what's in the estate and what the priorities are worth. So I think he was wrestling with that. I'm kind of grateful he didn't go any further. That's my point.
Yeah. Well, I got to tell you.
Bill,
yes, go ahead.
I just wanted to jump in on two quick points in response to David. I think that the real elephant in the room was what effect this would have on plans. And so the thing that I think was one of the things that was most important, at least to us, and I think probably to Justice Breyer, is that ordinarily we expect that a case will be either resolved in a confirmed plan or there will be a liquidation. And in either case, right, the statutory priorities of 507 apply. And there are a bunch of important procedural protections for stakeholders in the plan process. And what this particular kind of dismissal did was achieved a result that you could not achieve under either 1129 or 507. And there were none of the procedural protections you would get in a planned context. So it, I think, threatens to sort of erode the use of plans. I think plans can be costly, and I think I might push back a little bit on the claim that this eliminates structured dismissals. It doesn't at all, and Justice Breyer is quite clear at page 14. He says we express no view about the legality of structured dismissals in general. I think he's simply saying that if you read the code holistically, it's pretty clear that Congress did not intend to, I think he's quoting Justice Scalia saying Congress doesn't, hide elephants in mouse holes, right? So they didn't hide this, way to kind of alter the priority rules through settlement by, inadvertence, right? They intended that in the final distribution, you either recognize priority or you obtain consent. And so they, I think other important thing here is that they're not prohibiting, I don't think, alterations of priority. I don't know where the word sacred comes from, but it's not sacred, right? People can waive their rights all the time. And as we pointed out in our brief, like if you actually look at what happened in Iridium, right, the Second Circuit sent it back, there was a negotiation, and the parties settled, right? And, our view was that that's what the Third Circuit should have done, and didn't. And so now it's the Supreme Court's job to do that. I don't know that I read Justice Breyer as really being a strict statutory constructionist. I think there is some of that, but he also says at several points, it's important to read the code holistically. And, I think that that's an interesting question. Like, is he suggesting, a move away from strict textualism that we might have associated with Justice Scalia or not? But in any case, I think that, to me, the real elephant in the room was about the plan process and the procedural protections that Congress built into Chapter 11, which, structured dismissals of this particular sort, priority skipping structured dismissals, would threaten to eliminate, problematically if you don't even know when you can do them, which is the problem that the Third Circuit left us with.
Right. Yeah, I'm going to come back in a minute to the basically the plain meaning issue, but I'd like to observe that almost inevitably on every argument in a bankruptcy case in the Supreme Court, Justice Breyer will say, well, listen here, I really don't know much about bankruptcy law, and I don't know much about how things really work in the bankruptcy court, and he will often ask counsel to tell him about the realities of practice in the bankruptcy court. But then he turns around and writes an opinion like this, which shows a very good understanding of the reality of life in bankruptcy court. I think what we have here in Justice Breyer, with his opinion, he has now established himself as the 21st century's William O. Douglas when it comes to writing bankruptcy opinions. Of course, the other primary author of bankruptcy opinions these days for the Supreme Court is Justice Thomas, who seems to write the opinions when they are plain meaning opinions. And in that respect, I'd like to ask the panelists, is this a plain meaning decision, or is it a decision about congressional policy? Which is it?
Maybe neither.
What in terms of Supreme Court?
I don't think there's a Bill. I don't think there's a. I don't think it's like a Radlax case where there's a plain meaning that they're looking at. I think 507. Look, if you start with the proposition that 507 is critical and means what it says at the end of the case, but it may mean something different at the beginning of the case, which is Breyer's insight into the real world of bankruptcy, then I don't think you can say it's strict constructionist. So I think, in an odd way, he is closer to Justice Douglas. I mean, Douglas was the one who came up with the new value corollary, and he was the one. He actually supports our brief. Our brief said if you look at the history of absolute priority, it's moving toward greater flexibility, not less flexibility, and I think he started that ball rolling. So I would not. My view is I would not call it a strict constructionist. I would call it a very realistic decision, and one that invites some flexibility at certain stages. I know that there was a lot of discussion before the case on the respondent side that an overbroad decision could extremely injure bankruptcy practice. And I guess that depends on your view of the need for critical vendor motions and first day motions and all of that. And he didn't do that. He made clear, because I reread the oral argument earlier today, he made clear he was worried about that. And his opinion makes it doubly clear he was concerned about that. The only point I would make is that the Solicitor General made it clear they're still going after that stuff. So I think the Solicitor General twice said in oral argument, we think first day motions do violate the very same principle being advanced here.
Bill, I'll tell you, I think I agree with David, but there is something to the analysis here. It's a very plain meaning sort of analysis, and you look at the cases that Justice Breyer cites in support, he often cites Justice Scalia cases. He cites the Seventh Circuit Kmart case that struck down critical vendor orders on plain meaning grounds. He uses a plain meaning sort of structure, but there is no plain language in the statute that he's interpreting. He's really applying, so we're in a sort of weird world where you're using a sort of a plain meaning approach to interpret statutory silence. How do we justify, there is no statute that provides for structured dismissals of this sort. So he uses a plain meaning analysis to say, how should we read into that silence? And when we're dealing with silence on an issue that is as fundamental as bankruptcy priority, he says, we shouldn't go too far. And assuming that by not prohibiting these, that we allow them.
I think there's also a long tradition in the Supreme Court of acknowledging existing practices, and that in effect there is a federal common law of bankruptcy practice that fills the gaps where the statute may not speak. The question is, as I think Justice Breyer recognized, can you have a potentially significant deviation from what the statute appears to be trying to do, and some of its language explicitly requires, and view that as simply another gap in the statute, or in fact, is it problematic in a way that requires us to prohibit at least this particular type of structured dismissal? And I think that's the right result.
Yeah. Well, listen here. First off, before I change the topic slightly, those of you in the audience, if you have questions, write those into the chat box on your computer screen, and we will endeavor to answer them later in the show. But like I said, let's change the topic a little bit. Previously, you all were talking about the elephant in the room, and now let's talk about what I might call the ghost that permeated the room. And the ghost, by that, I mean gift plans, the first cousin of structured dismissals. There is not a word in Justice Breyer's decision that says anything about gift plans. So, folks, my question for you is this. Does this opinion give us any guidance about what the Supreme Court might think about gift plans? And by the way, whoever pipes up first, please tell us what a gift plan is.
I'll pipe up first, but I don't want to tell you what a gift plan is. I'm teasing. Look, a gift plan, as I understand it, is a form of priority skipping where typically, so the argument goes, a secured lender will arguably give up part of its secured distribution to a class, skipping over an intervening class. And so I think it has much of the same feel. There's somebody in between who's being squeezed. The distinction being among courts who approve of this is that the distribution is not coming from estate property, but from the collateral of the secured lender. So assuming that's reasonably correct, I would suggest that both sides, pro and con, are going to use this same case to support attacking it and supporting it. Those who hate gift plans will pick up on the importance of priority that Justice Breyer argues about, and those who support them will refer to the holistic, no, this only pertains to interim where there's no countervailing Chapter 11 policy to make it valuable. So he took a stab at sub rosa plans, which is I think another cousin to gifting. It's just a remote cousin. So I think my feel, Bill, is that both sides will argue it. He left that open. I don't think he refers to, others may correct me, I don't see any overt discussion on gifting, but I think he leaves that open for further wrangling in the future. Yeah,
Bill, this is Jonathan. I tend to agree. I don't teach family law, so maybe I don't quite understand the cousin analogy, but I don't really think gifting has much to do with structured dismissals generally. It is true that there was priority skipping here, but the key in gift plans is that the senior secured is purchasing consent, right, or purchasing, a vote effectively. And while I think circuits have split on this, SPM says they're okay, DBSD, and Armstrong are a little concerned about them. To me, the fundamental, difference is that you do have plans in those cases, and there are the plan processes that protect creditors and other stakeholders that, the courts have to assess, and that's exactly what you did not have here. So it's not a surprise to me that there isn't a discussion of gift plans because there was no plan here. I think the sub rosa point is more important because, as I was suggesting earlier, one of our concerns was that this invites people simply to jettison the use of Chapter 11 plans entirely and just have structured dismissals in which the senior and some junior squeeze out the middle, but need not obtain anybody's consent.
Yeah, Bill, as David said, if I were opposing gift plans, I would cite the page and a half of this opinion that says how fundamental the priority structure is. But if I were trying to argue in favor of a gift plan, I guess I would look at the part of the opinion where Justice Breyer says as long as there's a bankruptcy purpose served, and he lists as one of the bankruptcy purposes that might justify deviating from the priority structure as promoting the possibility of a confirmable plan, which is often the justification for a gift plan. We had to give some sort of class skipping gift in order to get a plan confirmed.
Well, in that respect, Justice Breyer gives a reason for not adhering closely to the priorities when he talks about whether it preserves the debtor as a going concern. So I suppose one could argue with maybe some force that if you have to make a gift to get a confirmed plan to have a going concern, that is justification. Certainly will make an interesting case if it comes up.
Bill, this is Jonathan. I think that's right. I mean, one of the things that we were grousing about in the academics brief on the petitioner side was that, there are all sorts of things that might justify interim deviations from priority, but they're connected in some important way to bankruptcy policy, like they help keep the debtor going so that it can, in fact, get to the end and confirm a plan or, what have you. And, nobody on the respondent side ever offered any justification that had anything to do with the bankruptcy system. They just said, we like settlements. We promote settlements. We think settlements are good. And of course, that's true, but, that doesn't change the fact that there are, the bankruptcy code does have some pretty important guardrails meant to protect particular stakeholders. And one of those guardrails is are the priorities for, the workers in this case, the unpaid workers in this case, the taxing authorities, what have you. So, that sort of, to us, it was, the bankruptcy policy point matters, and I think helps, kind of cabin what Justice Breyer said here.
Right. Well, listen, I want to change the topic in a second, but before I do, I would like to observe that likely is not the primary beneficiary of the Jevic decision is the Internal Revenue Service. They are more often than not the folks whose ox are gored because they will, with some frequency, have priority tax claims that are skipped over in these structured settlements. Indeed, the government could have filed a petition for certiorari in just such a case, but they didn't. Instead, the Supreme Court took on Jevic, but nonetheless, that I think explains why the Solicitor General and the government came down on the side of reversing the Third Circuit. But like I said, I have a different topic that I would like to raise from this opinion, and that is the question of appellate standing. This is a not unimportant case on appellate standing in bankruptcy. Would one of you folks like to address that issue as dealt with by Justice Breyer?
Sure.
This is Jonathan. I can go ahead, Drew.
Oh, okay. Well, really, like the issue to have appellate standing is that there has to be an actual injury in fact, and part of, again, this sort of relates back to the argument that carried the day in the bankruptcy court, which was there really is no harm to the Warren Act claimants here because the settlement, true, skips them and gives them nothing, but without the settlement, they would receive nothing as well. So either way, they're not getting anything. What are they complaining about? It's it's never no harm, no foul sort of rule of appellate standing. And
I think that the thing that made this case different from other structured dismissals was the fraudulent transfer cause of action. And so the supposition that the priority creditors were totally out of the money was not really tested, right? If the fraudulent conveyance action succeeded, right, and it had survived motions to dismiss, then the estate would have come into very large sums of money, in which case all of the priority creditors would have been paid in full. And so Justice Breyer's point is like, you don't need a lot of potential injury to show standing. But I think that the fraudulent transfer cause of action ends up being very, very important because otherwise this case ends up looking just like LCI or other cases where, the government does come in and does complain, and the courts, I think, effectively say you don't really have standing because the secured creditors locked everything up and they can do whatever they want with their collateral.
This opinion in this regard was, to me, rather interesting in terms of whether I could discern anything that approaches the issue that the Supreme Court ducked last year in the Spokio decision. That is an issue, the Spokio issue, that will come back to the Supreme Court, as sure as God made little green apples, in terms of cutting off, especially consumers, from bringing complaints when they really can't show concrete injury. Do any of you have any view about whether this decision says anything at all that's informative about Spokio issues? Or is that still just very much hanging out there untouched?
I don't know if this is terribly responsive, Bill, but I guess it kind of comes down to there isn't really a concrete injury in fact here. I mean, I think Jonathan is right. The thing that makes this case special is that it all hinged on valuation of an uncertain fraudulent transfer action. And in some sense, in order to find standing, the court just didn't accept the findings of the bankruptcy court as to the value of that fraudulent transfer action. If you accept that there wouldn't be anything available, then there is no harm.
Yeah, I don't disagree. I just wonder, it's just a question, David, that, the judge was fairly careful. The record showed that nobody volunteered or expressed any interest in taking the case on a contingency. And then, of course, the judge had that comment. I think he said you'd have to be crazy to take this on a contingency. So there was a factual finding of some kind that nobody expressed any interest. You could say that there was kind of a waiver or an abandonment of it. And I don't see where anybody disputed that, in the appeal. So I don't disagree there's some potential value hypothetically, but I don't think the record showed anybody was interested in going after it or assuming the economic risk of going after it.
Right. Well,
one of the things that I think is important about this structured dismissal that isn't addressed at all in the opinion, we talked a little bit about it in our brief, and I guess Justice Breyer mentions it but doesn't really go at the issue directly, is, okay, well, if there was a fraudulent transfer cause of action and the case is dismissed, could the truck drivers as creditors pursue it? Well, under the UFTA, the answer should clearly be yes, right? They have standing. But, I think a fair reading of the settlement agreement in the case and the order approving it would have made it very difficult, if not impossible, for the truck drivers to do that. So, why the truck drivers below didn't raise the issue, I don't know, I wasn't involved in the case, but it seems to me that in part, the whole motive for CIT and Sun in getting this settlement structured in the way that they did was to foreclose any possibility that anybody could attack them on fraudulent transfer grounds. And so, again, that's why I think that the fraudulent transfer cause of action is important, and it sort of bespeaks the fact that there was value, right? They paid $3 million to get out of it.
Right. By the way, I'd like to point out that the standing discussion in this opinion dealt with appellate standing, which is a different standard from Article 3 standing. Article 3 is whether there's a case of controversy, and of course, interestingly, the Article 3 standing is a lower threshold. To have appellate standing, you have to have injury. So, therefore, there's maybe some argument to be made that the discussion of standing in this concept, which is a higher standing than it would be in a Spokio context, is perhaps something at least to think about. Listen, before we wrap up here, I'd like to ask for you folks to address the issue of the dissent. I'm thinking that possibly, Mr. Tooney, you're the one to deal with it. Why is it that we had Justices Thomas and Alito dissenting from this opinion?
Well, I sort of understand their point of view. They took the position that cert was improvidently granted. I think they used the pejorative bait and switch. Look, there is something to that, of course. The cert question was whether the bankruptcy court can authorize a distribution of settlement proceeds in a manner that violates the statutory priority scheme. And so the focus really was on a settlement. It didn't really hinge on a dismissal nor a structured dismissal. In fact, in the briefing, I think the petitioners made it very clear the court doesn't even have to reach the issue of structured dismissal. By the time they got to the main brief, the question had been recast as to whether a case can be terminated by a structured dismissal. And I think it's, you can say those are profoundly, different issues. And Justice Breyer's opinion, to some extent, made that accurate. He said, the heart of his decision is there's something very different about a distribution at the end of the case. And I think what they said, what the dissent said, is that the unfairness here was that they weren't sure respondents had a fair opportunity to brief the case the way that it was ultimately decided. I suspect they did in reality, but I think there was an unfairness element. And there wasn't a circuit split on the way the case was presented because, there wasn't a circuit split on structured dismissals. The other cases had really been on settlements, interim settlements. So, there was a procedural oddity here. I think a lot of people did think it was going to be, the case was going to be dismissed on the grounds that cert was improvidently granted. So I sympathize with the dissent on this.
Well, that certainly is how it seemed at oral argument. There was a very evident push for dismissal for improvidently granted. And earlier in the term, the Supreme Court had dismissed another petition on precisely that ground. There is one other issue that's very close to the heart of Chapter 11 that's lurking out there. That is to say, third-party releases. I know I haven't discussed this with any of you panel members, so this may be, in that sense, coming out of the blue. But there are 3 or now 2 issues where there are splits of circuits. The split, to the extent there was one on structured dismissals, has been solved. There is also the gift plan issue. And then on third-party releases, also the circuits are split. The Supreme Court, it really has struck me, has stayed away from Chapter 11 issues. Perhaps it's because they don't seem to understand or fear they don't understand Chapter 11 that well. So instead, they get these very complex Chapter 7 and Chapter 13 cases that they answer. But do you all think that their having tackled this case indicates that they might like to take on the question of third-party dismissals, or excuse me, third-party releases?
So, Bill, if I can just jump in here, that was an issue that we came at pretty aggressively in our brief in support of the cert petition. So, as I was suggesting earlier, part of what motivated me, and I think the folks who signed on to the brief, was the fact that it looked like the CIT and Sun were getting the benefit of a third-party release without having had to go through the plan process, and we thought that was deeply problematic. You're correct. I think that the court has been asked to take the split on third-party releases and hasn't done so yet. I don't know whether this signals that they will. I do think that is it is related to the what I think of as the elephant in the room, which is the sort of underlying effect that affirming would have had on the integrity of Chapter 11 process generally. I think that releases may be important, but I think that there have to be procedural protections for folks who might be affected by the releases before you can just dole them out.
And of course, on the topic of third-party releases, if to the extent Jevic is any authority, you do have Justice Breyer talking about preserving the debtor as a going concern and emerging from Chapter 11. And at least the argument is made in the context of third-party releases that those folks who get the releases are typically paying money that enables confirmation. So perhaps Jevic is an argument in favor of third-party releases, but again, like you all said earlier, you can take the Jevic decision, find language that is very much to the contrary. Well, folks, we have taken almost 55 minutes of our audience's time. And as they say, enough is enough. We certainly appreciate the participation from all three of you on this very interesting topic. We have two more Supreme Court decisions that'll be in the works before the end of June. The next one will be on the topic of the Fair Debt Collection Practices Act. And within a couple of days after that decision comes down, we will be back with another one of these webinars. But until then, we thank you all for participating. We thank you for listening. And tune in again very soon to hear about the FDCPA. Thank you and good day.
Thank you.
Thank you, Bill.
Thank you.